Hi, my name is Chris Jackson. I'm a practicing business attorney. I have been one for the past 25 years. This video is about operating agreements for your limited liability company. Let's say you just set up your limited liability company, or if you set it up in the past, but you don't have an operating agreement. This video is about what is an operating agreement, why you should have one, and what should be in it. And if you like this video, please, I encourage you to click the thumbs up button. And if you are interested in this kind of content on a regular basis, I kindly request that you subscribe to my channel. So let's get right into it. The first question is, what is an operating agreement? And the answer is, it's an agreement between you, the member owner of the limited liability company, and the limited liability company itself. If you don't have an operating agreement, you are subjecting yourself to what's called piercing the corporate veil. And that means that if a plaintiff sues you and makes the claim that there is no operating agreement, therefore you're not really acting like a separate LLC, you're really just running the business as an individual, then you're subjecting your own individual personal assets to risk of seizure and forfeiture to creditors, and we don't want that. The whole purpose of creating this limited liability company is to protect you from the liabilities that may be incurred by the company itself. So it's really important that you take certain steps. I covered that in a prior video. I mentioned the operating agreement as being the first and foremost step. However, this video is really meant to go into detail of what should be in an operating agreement, and we're going to cover that next. Number one, the business name and address of the limited liability company. Number two, the registered agent for service of process. And I discussed this in a prior video, but essentially this is the person or company that could be you yourself, or you could have appointed a third party to receive service of process should the LLC get sued. Number three, the name of the member or members. If it's a single member LLC and you're the only member, you still have to identify your name and your address. And you also have to, with each member, identify what their percentage ownership interest is in the LLC. Of course, if you are a single member LLC, you're going to own 100%. If you have more than one member, then you're going to have to identify who those members are and what percentage they own. Number four, the capital contributions that are expected to be made by the members, either before or after the LLC is established. That can be a dollar figure. It can also include services that you provide to the limited liability company or have provided. But just make sure that whatever your capital contribution is, and it's easiest just to put in a dollar figure, maybe it's $100 or $1,000, whatever it is, you just want to make sure that it matches up with your membership percentage ownership. The next item in the operating agreement that you should include is the business purpose. Now, some lawyers on YouTube recommend a specific purpose for your specific type of entity. I, on the other hand, don't recommend that. You may have a purpose for the limited liability company that you have in mind when you created the limited liability company, and thus when you are writing this operating agreement. However, that purpose may evolve or change over time. So in my view, it's best just to provide a very broad purpose. And I will give you specific language that I recommend, generally speaking. The business purpose is to engage in any act or activity for which a limited liability company may be organized. That way, with that statement, you can pretty much do anything you want with a limited liability company. You don't have to be limited to a specific purpose. And then if you expand on what your business purpose was in the future, you don't have to then go back and amend the operating agreement. I just think it's unnecessary to make the business purpose too narrow. Okay, the next item you have to address in the operating agreement is whether your LLC is going to be either a member-managed limited liability company or a manager-managed LLC. I do not like member-managed LLCs for many reasons. I prefer manager-managed LLCs. I've spoken about this in the past, but I want to address it again in a little more detail. If you're a single member LLC, it doesn't really matter as much because, frankly, you are both the manager and the member, or you're the one member and you can make all the decisions. But assuming that there's a possibility in the future, or if at the time you form this LLC, you are going to have more than one member, but you are going to be in charge of the day-to-day operations, I would recommend for you that you should create a manager-managed limited liability company. And the reason is you want to have the discretion to operate the LLC as you see fit and only seek member approval where necessary. There are other reasons not to be a member-managed LLC. For example, in many states, you have to disclose the names of the members and their addresses publicly. So if a plaintiff in a lawsuit or anyone else that's interested in your company wants to know who owns that company and you are a member-managed LLC, then you're going to have to list yourself, and they're going to discover who owns the company, what the address is. There may be solicitations that you don't want to receive. For anonymity purposes, I generally recommend a manager-managed LLC, and don't disclose the names of the owners of the LLC. That should be secret. Furthermore, if you're in a member-managed LLC and you have silent members that are not actively involved in the business, maybe they invested in your business, but they don't really understand the business. They're hoping to make money in the future. You don't want to have to go to each of the other members who may or may not know anything about your business and ask them for permission for you to do X, Y, or Z. They could be stumbling blocks in the operation of your LLC, and I don't want that for you for all these reasons, and also the convenience of simply having the title as manager, which will help you sign documents, enter into contracts, open bank accounts, etc. I really recommend a manager-managed LLC. Okay, in the operating agreement, you also need to include the tax treatment that you are electing. And there are different options you have as a limited liability company. You can choose to be taxed as a sole proprietor. If there's more than one member, you can be taxed as a partnership. You can also be taxed as a C corporation. And lastly, you can choose to be taxed as an S corporation, which if you watch my other videos, you would know it's what I recommend in most cases. And if you do choose a tax status, whether it's S Corp tax status or otherwise, make sure that it is consistent in the operating agreement, because if there is an inconsistency and you are ever audited, the IRS is going to ask you, why does it say you're taxed, for example, as a sole proprietorship in your operating agreement, but you elected S corporation tax status by filing Form 2553? Maybe you should have been paying this extra 15.3% tax because you decided in your operating agreement, did not amend it, that you were going to be taxed as a sole proprietorship rather than an S corporation. So just make sure they are consistent. Okay, the next item is profit distributions to the members. The operating agreement should indicate how and when you are going to make profit distributions. In my view, in most cases, it is best not to be too restrictive here. You don't want an agreement that basically requires you to make profit distributions to the members if it's not a good idea, in your opinion, if you are running the LLC, to make those profit distributions. If you put it in the operating agreement that you have to make certain distributions, say quarterly or annually, then you have to do that. And if you don't do that, then you're not following the operating agreement, and then you're not really operating as separate from yourself. It's just an additional restriction that I think you should not include. Let's make it as flexible as possible. The only restriction you may want to consider, and this is at most in my view, is putting in the operating agreement that you will distribute to the members the amount they need to pay their tax obligation that arises from their ownership in the limited liability company, but I wouldn't go beyond that. Okay, if you choose to be a manager-managed limited liability company, you're going to want to identify what the scope of authority that the manager has. You want to essentially determine, okay, the manager can do X, Y, and Z without members having to step in and approve the manager's actions. The manager can enter into, for example, transactions up to, say, $100,000 without requiring the members to vote on whether they should enter into the transaction. Whatever the scope of authority you think is right for your particular business. If you are the manager and you're a single member, it doesn't matter as much for reasons discussed, because you're not going to oppose as member what you want to do as manager. You're essentially the same person. That wouldn't make any sense. However, if you have additional members and you are, say, the founding member and manager, you're going to want to have the broadest scope of authority available to make decisions without seeking member approval. The next item is, what should members approve? What should they be entitled to vote on? You have to address that in the operating agreement. And those items in a manager-managed LLC are essentially going to be whatever is beyond the manager's scope of authority. So if the manager has the right to enter into transactions for $100,000 or less without seeking member approval, then any transaction over $100,000 would require member approval. Then the question is, should you have the approval be by a majority of members, which I recommend for most items and most actions, which is simply anything over 50% of the members. You could also have certain actions require a supermajority, which tends to be 2/3 of the membership interest. And there are certain things that may require unanimous approval of the members. You want to identify those items in the operating agreement. Okay, the next item is transfers of membership interests. There should be two categories for this. There should be what's called permitted transfers, and that essentially means that you can transfer, for example, your membership interest in this case, when I say membership interest, it's like shares that you own in a corporation. The equivalent is a membership interest in a limited liability company. And so perhaps you want the right to transfer your membership interest to, say, your own living trust or to another company that is owned by you. So permitted transfers, you want to identify what is a transfer that does not require the approval of either the manager or the members or both. Other transfers, let's say you have a member that wants to sell their membership interest in the limited liability company. You need to consider what steps need to be taken. In most cases, I recommend in the transfer of a membership interest that the other members have the right to first purchase the membership interest of the transferring member, the member that is selling their membership interest. The other members have the right to purchase this before it is sold to some third party that you don't know and you don't necessarily want to be part of your limited liability company. So the members themselves should be able to have what's called the right of first refusal to purchase the membership interest of a transferring member. The price for which this membership interest can be purchased can either be, for example, agreed to by all the members as to what is a fair price for this membership interest. And if the members cannot come to an agreement, then maybe you have some third-party appraisers, maybe 1, 2, or 3, that determine what the value is of the membership interest. And then it can be sold first to the members. And if the members choose not to purchase the membership interest, then that transferring member will have the ability to sell the membership interest to this third party. Then the question is, and this is another item, do you want that third party to have any right to vote as a member? What rights does a transferee, third party that purchases the membership interest of a current member of your LLC, what rights does that transferee member have within the limited liability company? And what I would recommend, generally speaking, is that they don't automatically have the right to vote. They have what's called an economic interest in the LLC. They have the right to get their share of the profits according to the profit distribution split, but nothing more. They can receive money, but they can't vote. They cannot participate in the management of the company. You put in this protective provision because you don't want third parties that you don't know to be involved in decision making in your limited liability company unless you give them that right, you approve that right. Okay, I also recommend what's called charging order language or a charging order provision in the operating agreement. Essentially what the charging order is, let's say a member is in a personal lawsuit and loses. You don't want the court to be able to issue an order, a charging order, which allows that creditor to step into the member's shoes and exercise all the rights of a member in the LLC. We want to prevent that from happening. It can disrupt the business of the limited liability company. And so you need to add a provision in your operating agreement which essentially limits the creditor's rights to receive distributions of profits and nothing else. That's it. Okay, the last item that we want to make sure we address, and there are other items, but I just want to hit the major items. The last item is how to amend the operating agreement or update the operating agreement. So essentially, what approvals are required to amend the operating agreement? I would try to stay away from unanimous approval where you can. You don't want one member to have veto power. I usually stick to a majority of members and at most a supermajority of members that need to approve things such as amending the operating agreement. Well, I hope you enjoyed this video and you learned a lot about operating agreements. If you liked the video, I encourage you to select the thumbs up button, and if you want more content like this, I kindly request that you subscribe to my channel, and I wish you and your limited liability company all the best. Good luck, go get them. I'm rooting for you. Thank you.